Section C, Civil Law.
Okay, we are now going to actually start applying all of this law gobbledygook to business law, starting with civil law. Civil law is the body of law which is applicable to lawsuits involving two persons or parties. Criminal law, on the other hand, is different.
Why, yes, it is. Criminal law is a whole other breed of legal animal. For the purpose of this review, and most likely your business law class, all you really need to know when it comes to the difference between civil and criminal law is that in civil lawsuits, the plaintiff is the one trying to force the defendant to either do something, stop doing something, or pay the plaintiff money. The plaintiff can be a private party or the government. By the way, the plaintiff is the one who files the suit, the one with the complaint.
In criminal cases, however, the government is always the plaintiff. The government lawyer, the prosecutor, is trying to send the defendant to jail or force him to pay a fine as punishment for violating a criminal statute. Remember, in a criminal case, the plaintiff is always the government. So that's the one important difference you need to know between civil and criminal law. In civil law, the plaintiff can be a private party or the government.
All civil lawsuits, also known as cases, will have several common components. We're not going to get too sticky with detail here. We're just going to point out a few common traits of civil law and procedure. For the record, when we say procedure, we're talking about all the rules and stuff that have to do with civil lawsuits. Let's look at the important ones now.
Civil law procedure has several rules. There will be a plaintiff and a defendant. The plaintiff is the party who sues, and the defendant is the party being sued. Using non-legal terms, the plaintiff is the guy with the neck brace, seeking compensation for a harm that was done to him, and the defendant is the guy shaking in his boots, hoping he doesn't have to put a mortgage out on his house just to pay for the plaintiff's hospital bill.
Civil trials as well as criminal trials are based on the adversarial system. In other words, there are two sides to an argument, and each of these sides presents its position. There will always be a judge, and also a lot of the time there will be a jury. The judge determines what the law is that applies to the case. The jury determines what the facts are and applies the law to the facts as they find them. Also, both of these players, the judge and the jury, have the ability to determine the guilt or innocence of the defendant.
Lastly, when it comes to civil law, there's an important legal concept to keep in mind, and that concept is preponderance of the evidence.
Preponderance of the evidence means that the majority of the evidence supports one side of the case.
So what's so great about preponderance of the evidence? Okay, well, you see, in civil law, one person sues another for whatever reason. Breach of contract, negligence, and a bunch of other possibilities, which we'll discuss later. Now, the person that is suing doesn't have to prove to an absolute certainty that the defendant is at fault. Nope, absolute proof isn't necessary.
Here's a preponderance of evidence tidbit. As long as majority of the evidence supports the plaintiff's claim, then the plaintiff will most likely win the case and collect something. And of course, if the majority of the evidence supports the defendant, well, then the defendant will win. But what is a majority? Well, it's at least 51%, right? That's a majority, 51%.
So, in order to win a case in civil law, you need a majority of evidence supporting your side of the case. Just keep this concept in mind when we go over torts, contracts, and product liability in just a little while.